keynote address at the Global FRAND and SEP Symposium of 2022. I regret that I'm unable to join you in person to discuss the constantly evolving SEP landscape. Ladies and gentlemen, WIPO, as a UN specialized agency with 193 member states, is the global institution for IP services, policy, information, and cooperation. Our mission is to lead the development of a balanced and effective international IP system that enables innovation and creativity for the benefit of all. In my role as Deputy Director General for the Patents and Technology sector, I oversee WIPO's programs relating to the policy and law of patents and technology, as well as their full practical application, including the administration of the Patent Cooperation Treaty, or the PCT. As part of our mandate, we assist individual member states, when requested, with shaping and implementing their national and regional normative framework in the field of patents and related forms of IP. Working with member states as a community, WIPO conducts activities to support them in the progressive development of the international patent system. In that capacity, we serve as the Secretariat of the Standing Committee on the Law of Patents, also known as the SCP. The committee provides an inclusive forum for our member states to discuss pertinent issues of patent law and policy, to share their best practices and experience, and to find a common baseline in matters they choose to address. Turning to the matter at hand, it comes as no surprise to this audience that the IP community has faced some challenges in the field of technological standardization. With over 20 years' experience in IP licensing, largely around semiconductor technology, I have firsthand experience on how challenging the negotiation of license agreements can be. Therefore, I consider the topics discussed at this symposium as highly relevant and congratulate the organizers for putting together such a diverse program. In the last 2 days, you have heard from standard-setting organizations, judges, academics, and practitioners about the global impact of standardization's law, the challenges in adjudicating SEP disputes, as well as on current global developments, including those connected to the IoT. Standardization is an issue of global importance. Standard-setting organizations provide an open, inclusive, and collaborative environment to their members. In turn, this environment supports the rapid development, ratification, and testing of global relevant standards for systems, applications, and services in the ICT field. Interoperability achieved through technological standards helps to lower costs for all involved, and it lays down the foundation for a competitive market at the consumer level by enabling customers to base purchasing decisions on features other than connectivity, such as price or design. On the one hand, one can describe the voluntary collaboration of competitors organized by standard-setting organizations as a great success story, as it has led to a high degree of innovation and some of the most widely adopted technologies in the history of mankind. On the other hand, it is well known that the standard-setting environment comes with its own set of challenges. A body in which competitors develop standards that incorporate proprietary technologies is, by design, at the interface of IP law and antitrust law. It is therefore necessary to establish and implement a solid FRAND licensing system so that the benefits of technological standardization flow through to the society as a whole. However, the implications of a FRAND commitment made at SSOs, as well as the antitrust laws themselves, are not interpreted in an equal manner globally, regionally, or even nationally. In SEP licensing, and consequently in litigation, several topical questions have been contentious over the last decade. Open issues include, are essentiality checks needed, or will they be counterproductive to higher transactions costs, especially considering the debated reliability of AI-assisted solutions? What are the requirements that patent owners need to meet before suing? Is the FRAND declaration to be understood as a contractual third-party obligation? And if so, to what extent? What are the preconditions of a FRAND license offer? And what are the obligations of an implementer to be deemed a willing licensee? These questions get even more complex in the IoT environment. As you are aware, opinions differ on which level of the value chain a FRAND license needs to be provided. The basis of such a FRAND license fee is not clear either, yet it makes a huge practical difference whether the FRAND license fee is based on the smallest saleable component, the end product, or something in between. This is particularly true when it comes to complex and expensive end products such as cars. Even without considering those additional challenges of FRAND licensing in the value chain, the calculation of the FRAND rate is a topic that inspires heated debate. Naturally, these questions are brought to courts in several jurisdictions. Courts around the world are considering whether a FRAND license rate should be calculated based on comparable license agreements or via a top-down approach. They are also deliberating whether injunctions are available, and if so, under what conditions. Even in countries where injunctions are more or less automatic, demanding high security deposits from the SEP owner may be a hurdle to enforce a sales ban. This spring, a German court ordered an injunction and the recall of delivered cars due to an infringement of an SEP, setting a security deposit of €250 million. In 2020, another court granted a similar injunction against a different car manufacturer, but demanded a security deposit of €7 billion. Staying with the SEP litigation scene, for some years now, courts in certain jurisdictions have been prepared to move towards assessing or even determining a global FRAND royalty rate. Legally, the courts can enforce the FRAND rate only in their own territory of competence, even if it was calculated globally. Still, it sets a precedent, which has recently led to a race for the authority of the FRAND rate interpretation. To protect their jurisdictional sovereignty while computing such rates, courts have issued anti-suit injunctions, and as a countermeasure, anti-suit injunctions. This phenomenon that can be seen as judicial competition may effectively limit the enforceability of SEPs and make the litigation in this area even more complex. It is even raising disputes between certain jurisdictions, calling into question the compliance of such practices with international trade rules. In the light of these challenges in the SEP landscape, it appears that there is a growing need for information, guidance, solutions, or services at the international level. Jurisdictions such as the European Union, Japan, the United Kingdom, and the United States are considering what policy options they have to complement existing or emerging market mechanisms, such as patent pools, licensing frameworks with targeted incentives, and technological solutions. Given the lack of consensus even on fundamental issues between the strong-positioned SEP holders and the often equally strong implementers, it hardly comes as a surprise that these policy developments face challenges and may also tend to retreat towards case-by-case scrutiny. As there is no track record of successful regulatory solutions, most stakeholders seem to prefer a market-based approach. However, policy initiatives and consultations around them invigorate the discourse and tend to bring players closer to each other. At a bare minimum, enhanced transparency of the SEP landscape for interested market participants is called for. WIPO is currently closely monitoring the lay of the land and the SEP policy developments in our member states. At the same time, while remaining at the disposal of our membership to provide a discussion forum in this regard, we are also working on identifying those areas where WIPO may meaningfully contribute to the discourse around SEPs as a global and neutral body. In order to better understand the views and needs of the member states and stakeholders involved, WIPO has started a stock-taking and information-gathering exercise. The outcome of this process cannot and should not be preempted. WIPO's role and strength lies in its global outreach, its neutrality, and its technical and technological expertise. As such, we continue to offer an open forum for global multilateral dialogue, provide resources for targeted research, or even deploy some technical functions that enhance transparency in this field. Already, WIPO is a venue for alternative dispute resolution in SEP cases, as you heard earlier from my colleague Ignacio de Castro Llamas. The Memorandum of Understanding between the USPTO and WIPO underlines our enhanced efforts in this domain, and we are hoping that it will attract more out-of-court settlements and renewed negotiations between parties. As you may also be aware, the Standing Committee on the Law of Patents mentioned at the beginning of my remarks agreed at the end of September to introduce SEPs in its agenda under the Transfer of Technology heading. Accordingly, at its upcoming meeting, the committee will provide a platform for information exchange on the practical experiences of relevant stakeholders relating to standard essential patents and FRAND licensing. This has the potential of facilitating mutual understanding of the issues encountered by various jurisdictions in this field. In summary, let me underscore that patents, in particular SEPs, serve the purpose of encouraging innovation, and standards serve the purpose of promoting interoperable and safe technologies. These goals are complementary and have the potential of mutually strengthening each other, provided that the legal mechanisms behind them work together harmoniously. Bearing this in mind, ladies and gentlemen, let me conclude with the words of H.E. Locke. No one can whistle a symphony. It takes a whole orchestra to play it. Thank you very much.
Before we close the 2022 Global FRAND and SEP Symposium, I just want to acknowledge some people who helped make this possible for all of us. I can't read all the names, but you'll recognize the faces. It's been wonderful to see old friends and meet new friends. Another acknowledgement is to our platinum sponsor, McCool Smith, who, like all our sponsors, helped to make this event possible. I'd like to thank Cater2, our caterer, and FN Tech, who did a wonderful job producing this event. Thank you to all of them. And of course, thank you to the Executive Director of Bauz IP Law, who put in an enormous amount of time to make this such a fabulous event. Thank you, Maria, for your help. And now the Computer History Museum has done a wonderful job as well, and they're leaving 25,000 square feet of their museum open for us during the networking reception. So thank you to the Computer History Museum as well, and we look forward to seeing you downstairs where there will be not so small plates to enjoy. And thank you for those remote participants as well who joined us from 3 continents, as well as our speakers and moderators who also joined us from 3 continents. Thank you very much. Enjoy.